Third and final day. Tesla Inc. and another against Interdigital Patent Holdings and others.
Mr. Raphael.
Good morning, my lords. I'll go back to one point on Gateway 11. In a question, the court raised the last sentence of Vestel paragraph 71, which is at page 3055, where Lord Justice Burst observed that if he took a different view to the judge below, it may have been because the claim before the judge below had not been narrowed in the way it had been before him. The short point I make is Tesla has not narrowed its claim. Though it has its artificial wording in Declaration 5, the rest of its claim is not narrowed. So, even if Vestel is correct, which it is not, we win. That's the short point on Gateway 11. I'll then return, if I may, to 6314. Yesterday, I was taking you through the Vestel logic, which fails, because this claim is not about a license to challenge patents, which just extends worldwide, nor is it about undertakings attaching to the challenged patents. Just to add to that, one easy test of the concept is this. Ask what would happen if the challenged patents were cancelled voluntarily, as could easily happen. Would the claim come to an end? It would not. It would be exactly the same claim, continuing in exactly the same way. And similarly, would a res judicata on this claim be a res judicata as to contractual obligations only to a license to challenge patents? It would not. It would be a res judicata as to obligations worldwide. And that is conclusive. So that disposes of, we submit, the Vestel logic.
Sorry, can you just explain that res judicata point to me again?
Well, if res judicata looks at the essence of a cause of action, if therefore I am correct that the res judicata would be as to obligations worldwide and not just as to a license to challenge patents that extends worldwide.
Sorry, I think it was that sentence that I wasn't quite following. When you say res judicata as to, res judicata between whom?
Between the parties.
Between the parties, right.
That's right. Because that could happen. You could have litigation in another forum where a res judicata as a license terms could be relied on.
Right. It obviously wouldn't be res judicata as between other parties.
No.
If you had a Chinese SEP owner, they could litigate
irrelevant.
All the issues we've been talking about anew in that forum.
I'm just talking about the parties.
Yes, okay.
So, and once one understands all that, you can see clearly this claim is not really about the challenge patents, which are 3 out of 170,000 plus. And that leads to Tesla's final throw of the dice, which is an argument that relating to a registered right is much broader, catastrophically broader, we should say, than Gateway 11. The argument has to be that relating can include loosely connected to, or connected to is only a small part of what's in issue. And we submit that on a natural reading of the words, and when understood in historical context, that's not what 6314 is there to do. Relating means really about. You have my example of Wilberforce and Huxley. It's not intended to cover claims connected only in very limited part to the registered rights with the address for service. And Global and Wadhawan is again instructive. When looking at 6314, you need to focus on which right the claim is made under or as to. And it's not enough to say that the claim relates to X, when in reality it relates just as much to X, Y, Z here, 170,000 others.
Could you just give me the reference to that again, please?
Global and Wadhawan, my learned junior will dig that up. Yeah. That reading is reinforced by the legislative history, which I've shown you, and it's further reinforced when you look at 6314 in the context of the gateways. Because if relating to in 6314 were given the broader meaning of merely connected, that would transform 6314 from a narrow IP-specific provision into a wide-ranging jurisdiction for non-IP rights merely with some connection to a patent. That would deform the structure of 6b. It would carve a huge hole in the intended limitations of Gateway 11 as to wholly or principally. And to really understand how dramatic the consequences of this are, you need to stand outside the Franz silo and consider what we're doing here, analysing this gateway and setting it for the future in the context of the law as a whole. Because it would mean, for example, that in a claim to enforce a contract of sale over a worldwide trademark portfolio for thousands of trademarks governed by foreign law, that would fall within 6314 if one trademark was in the UK. And the jurisdiction created would be by way of service in, and so would reverse the burden of proof on forum, another dramatic consequence. And in turn, that would produce an irrational difference between jurisdiction over claims connected with registered rights and claims connected with all other rights, including unregistered rights like copyright, which remains subject to Gateway 11. The reference to Global and Wadawan is page 1787, paras 61 to 64. Now, I've given you one example. Examples could be multiplied across the whole field of contract, tort, and all sorts of other claims. So what TESA is asking you to do is to legislate for what it says is the convenience of FRAND litigation and to transform 6314 into a wide-ranging provision for all sorts of non-patent claims which it was never intended to do in ways that would distort the entire structure of jurisdictional law, where there is some connection to registered right. And all this is meant to be done for FRAND claims which there is no basis to identify as being within the purpose of the legislature to capture when they set these rules. Well, before moving on, I'm going to touch on one argument that Lord Justice Arnold made in this regard. Lord Justice Arnold argues that the claim falls in 6314 because its purpose is to ensure that Tesla cannot be sued for infringement of IDD's SEPs. Among others, is the words he used. That's 210 of his judgment at page 289. But among others is a tell. The point fails also at three levels. Firstly, the claim has to be about the challenged patents. While Lord Justice Arnold said, oh, it's going to be the same for the rest of IDG's portfolio in the UK, he has absolutely no basis for that. There is no evidence, no suggestion that all the other IDG SEPs have the same address for service, and Tesla never relied on that. That's SOFI 44. Secondly, the claim is not for non-infringement. It seeks a declaration to a worldwide platform license. That might not be granted whatever happened on the declarations. A contract right for a claim for a right to transference of property is not the same thing as a claim for non-liability for trespass.
Right, but I mean, the declaration is sought as a method of bringing forward in time the issues that would be determined if it were a claim for infringement.
Well, that's actually an artificial construction.
Right.
It's to get a global license. One possible downstream consequence of that, if the license were granted by Avanci after some process of revision within the platform, that would have consequences. The downstream consequences are not the same as the claim. So I'm very grateful for that question because it identifies a key point.
But that may be the downstream consequences of a ruling on the claim. But I would have thought that the claim is precisely to bring forward in time and test the viability of an infringement claim that would be brought on the basis of the UK SEPs if Tesla started to do things which infringed them.
Again, that's picking a part of things, a part of the consequences, and not the whole. The shorter point is Tesla wants license terms. It wants a contract, whether or not there's infringement.
For the sake of argument, if one were to characterise the position as I've just put
Yes.
to you, would you accept that what Lord Justice Arnold says at paragraph 210 is correct?
No, because
Right. Why not on
indeed,
that basis?
then you take the next stage. Let's us. Firstly, it's still more artificial to describe the claim as about non-infringement of the challenged patents. There's no basis to think Interdigital ever sue for infringement at all, but it's still more artificial to suggest it's about non-infringement of the three challenged patents which no one has ever suggested have any particular relevance. It's also artificial for this reason. Tesla is not concerned about infringement litigation by Interdigital. That's not its purpose. It wants to change the rate. To the extent anyone's ever threatened it with infringement, it's not Interdigital. It's the people who threatened it under the 4G license, who are other people in other jurisdictions. And you cannot say, my lord, that the claims are relating to the challenged patents because of entirely speculative connections wholly speculative, to non-infringement of the challenged patents, which is what we're concerned with. And finally, my lord, and again this is also an answer to your point, which is a very useful point to test these issues by reference to, even were the hypothetical possibility of non-infringement relevant, it is just as much, indeed more, about infringement of all patents worldwide. That's the reality. There's nothing to connect infringement risks to the UK.
Right, but why isn't the reality in terms of the actual claim being brought here to focus on the UK steps of Interdigital? And why does one have to look more broadly for the purposes of application of 63.14?
Because the claim is for a global license, my lord.
Right.
Always
okay,
have.
That's what it comes down to. Yes.
I just read the pleading is our short answer on that one, really. So these ideas cannot make the claims relating to the challenged patents of 370,000. No reasonable business person would ever reach such a conclusion, and we'd submit only a very enthusiastic lawyer. So that's our submission on Lord Justice Arnold's infringement point. My learned friend referred you also to Amazon and Interdigital, which you find at 1352 of the bundles, and the relevant page is at 1377. Generally, it's just me was just applying Vestel. I don't think you need to turn it up, but if you go to paragraphs 13 to 15 of his judgment, at 1356, he's basically saying, I'm applying what's happened in previous cases. But then, at 1377, at paragraph 59, he adds one point. I should stress, though, this is a case involving Interdigital. I wasn't there, and the arguments were rather different. Indeed, they were recognising, in effect, that the point was dead at first instance. Now, what the comment that is made by Mr. Justice Mead is at 69. And he disagrees with Interdigital's arguments, saying it's no trivial matter for a party to have patents in the jurisdiction, and the gut point is it's entirely sensible that claims about patents can be served in the jurisdiction as of right. And Lord, I need to confront that, but there is a short answer to it. It's all about the word about, because what that begs the question of is what claims are about the patent. Now, if you're adopting the Vestel logic, then the claims about the patent will include worldwide licensing claims somehow. But if I'm right on Vestel, Mr. Justice Mead's logic doesn't help Tesla. Indeed, the situation reverses, because then what you do when you look at the purpose of 6314 is it's not intended to bring such claims which aren't about the patent in the relevant sense within the jurisdiction. I should also add, as a point of detail to an extent, that Mr. Justice Mead is wrong to think that 6314 is a universal provision for UK patents. In fact, the Patent Rules 2007 only require the patentee to furnish an address for service in relation to applications for UK patents, to the UK IPO. There's no requirement that assignees have to give an address for service. There's no requirement that the owners of EP-UKs have to give an address for service. And we set out the reference to that in our written case at paragraph 141 on page 100. And that point illustrates again that this provision, 6314, is not some provision for universal patent litigation intended to deal with a whole range of things outside patents. It's a technical provision for patent litigation only. Well, that's the construction of 6314. And I now address the point I promised my Lord Briggs I was going to come back to, which is the policy considerations and asymmetry, issues that Tesla stress. Tesla suggests its case is supported by policy. It argues there has to be a gateway for implemented claims, and this claim, as otherwise there would be a supposed asymmetry compared to SEP-holder infringement cases. It also suggests, wrongly, that if Interdigital is right, implemented declarations can't be brought at all. Underlying this is an unspoken assumption that the English courts should assume universal jurisdiction over worldwide FRAND, and that is a self-evidently good thing. But there is no basis for that assumption. Tesla's argument would mean that if one patent out of thousands is in the UK, you have an automatic gateway and indeed service in. You then combine that with Lord Justice R's conclusion that there's no such thing as convenient forum for FRAND, and you have automatic jurisdiction without possibility of forum convenience. This has had already dramatic consequences in the case law below.
Well, you have automatic jurisdiction in respect of that patent claim. It's just that resolving the issues in relation to that patent claim might have knock-on consequences for other things as well.
Universal jurisdiction in relation to that licensing claim as to worldwide FRAND.
Right, okay.
If in an infringement claim, where
Yes.
the claim is based on the infringement of the
Yes.
UK patent,
Yes.
the court has to determine what a FRAND platform license
Yes.
would be in terms of terms and rate,
Yes.
then I don't think you dispute that the UK court would have unquestionable jurisdiction.
Well, that's what this,
in that question.
That's what these courts have held in Unwired,
Yes.
and that's what the effect of the Court of Appeal's decision in.
And the asymmetry point is that your submission as to what happens if there happens not yet to be an infringement claim produces an entirely different result.
Can I come on to the asymmetry? Because that's,
So although the court would go there if you brought your 5G car into the UK and infringed, or allegedly infringed, it wouldn't go there if the car is still waiting in Calais and Tesla says, well, before I bring it across the channel, I want to sort this problem out.
let me come to asymmetry, because it's the next point in my notes. And it's obviously an important point to address. But first, let's set a bit of context to it. It's wrong to say that giving gateways their natural interpretation would defeat implemented claims generally.
Sorry, I didn't know that.
I'm sorry, I am too soft sometimes. It's wrong to say that giving gateways their natural interpretation would defeat implemented claims generally. Firstly, implemented claims will be possible wherever there is a basis for personal jurisdiction. For foreign defendants, that can always be done wherever they are based or have a relevant branch, or in France, subject to the French law provision. And there is nothing wrong with that being the basic rule. The principle you presumptively sue someone for personal causes of action where they are is at the heart of private international law. So firstly, you can always do it wherever they are, under the same law, French law. It will also be possible to bring an implemented claim in all situations where English jurisdictional law does so provide. So, if the defendant is present here, or where a natural gateway applies, such as where the relevant contract fits within the contract gateway. That would happen under Gateway 6 if a contract was made here, or if the SSO rules are governed by English law, which is a choice implicitly of English jurisdiction. And that does happen. The GSM rules, I think I said GTU yesterday, I've been corrected. The GSM rules provide for English law, and the references to that are in 145 of my written case. Likewise, if I may just finish the whole set and then I'll...
Yeah.
Likewise, a declaration claim genuinely as to UK patents alone could fit within the gateways. And further, in a platform claim, a platform based here could be sued. In this very case, Tesla could sue Vodafone or BT, who are both licensors. And finally, of course, if there ever are any SEP holder claims for infringement in the UK, FRAND can be raised by way of defence. So Interdigital's argument only means that implementer claims cannot be brought here where they do not have one of the connections to the jurisdiction that the Rules Committee has specified.
But does this add up to anything more than saying, well, the asymmetry wouldn't be complete because there would be cracks in it?
It's a bit more than that, Lord, if I may. Firstly, it wouldn't be complete, but also it would only exist in those situations where the legislature has not intended to bring parties before the jurisdiction. And standing back, there is nothing odd about the idea there might not be a gateway.
Sorry, just on that.
Yes.
I mean, that in essence begs the question, because I think my Lord's point is there would be undoubted jurisdiction in the English courts if it was an actual infringement claim based on, and the jurisdiction was based on CPR 63.14. Why should there be a different jurisdictional approach where all that is being done is that Tesla is seeking to test precisely those propositions in advance by invoking the discretionary power of a court to give declaratory relief? And as I've understood your answer so far, my Lord characterised it, seemed to be aptly, that you say, well, you've given us a conspectus of all the different ways in which jurisdiction might be asserted in a whole range of different cases in different ways. But they would have their own impediments as to whether you can get through gateways, what the burden of proof is on appropriate forum and so on. And so it seemed to me none of those actually addresses the asymmetry point that's being put to you, if I may say so.
Well, in a sense, it's a question of how you look at it, my Lord, obviously.
Right.
But coming to that exact point, why is there jurisdiction in the SEP holder case? It's not because there is jurisdiction over the Fran declaration were it sought independently. You've seen from conversant, there's only jurisdiction because it's an embedded part of the relief for infringement.
Yeah.
Now,
Forgive me for jumping in again. That's true in the declaration case as well. That's what's being sought to be tested in the declaration case.
well, the whole point I've been trying to put to you is no. In the declaration case, you are seeking contractual rights. There's nothing embedded at all. It's totally unconnected from SEP.
No, but surely in the declaration case, I mean, the way I'm thinking about it at the moment is you've just brought forward in time the very matter that you would wish to have tested if it was an actual infringement claim. You accept, I think, that in the actual infringement case, although the ETSI obligation is a contractual obligation, we all understand that, it's embedded in the, as an issue to be resolved in the claim for an infringement of the patent.
Yes.
Well, why isn't that equally true in the declaration case, which is simply seeking to test in advance the very same propositions that would be tested in reality if one had an infringement case?
Well, two answers to that, if I may. The first is, it's by no means unusual in jurisdictional law that you have a properly defined jurisdiction over X, because, for example, it's a contract in the UK, and then certain things are ancillary to that, which you would not otherwise independently have jurisdiction over. All the dependent gateways do that. 3, 4A, and so on. Likewise, there'll be situations in other kinds of in-rem claims. Let's imagine a contractual point comes up in the context of wills or insolvency litigation. It does happen that certain things can be ancillary to a claim over which a basic jurisdictional attachment is properly established. That is all that's happening here in the SEP holder cases. The jurisdiction of the court comes from the patent and from infringement of it, and the claim for infringement, and there is an ancillary question of relief. If the Court of Appeal in conversant had concluded that the declaration was not embedded, not part of the relief, it was just brought alongside, they would have rejected jurisdiction.
Right. But why isn't all that true of the declaration case, which is seeking, as I say, to test in advance precisely the propositions that would be tested in fact if it were an actual infringement case? I mean, I think you're accepting that in an actual infringement case, the embedded metaphor applies and there is jurisdiction. Why does it change when you're testing precisely those issues, just doing it in advance, invoking the declaratory jurisdiction of the court?
Well, the answer to that, my Lord, is this, is that the mere fact that an issue might be tested in one case because it's ancillary, connected in an ancillary way to something of which the court has jurisdiction, does not mean that in all other situations there should be jurisdiction beyond the definitions provided by the Rules Committee as to what is appropriately connected for a different cause of action, my Lord. Let's not forget that. So in the SEP holder case, the SEP holder has no cause of action in contract for the declaration at all. He is saying this is the license I am entitled to get to avoid an injunction, and he has talked right to an injunction. Whereas in our case, this is enforcing a contractual right. And that contractual right is one...
But only as a defence to the SEP holder's claim that you've just outlined.
Well, there I say, with respect, that you're wrong.
All right.
Because it is not in defence. You could be doing this contractual claim whether or not anyone ever sued for infringement ever anywhere in the world.
You could do that, but the context that it's the ETSI obligation is being relied on here is as a defence.
Well, again, no. This is a contractual claim.
All right.
And
This is all a very elaborate way of looking at what relating to means in 6314, which is an expression here used in that rule specifically in relation to intellectual property and,
yes.
and nothing else.
Yes.
And it seems to me that it is legitimate, isn't it, bearing in mind it's used in that very specific context, to start with the proposition that if the patent, say a UK SEP, is being infringed in the UK, then the UK is unquestionably the jurisdiction where you seek to enforce it. And therefore, relating to may bring on board the concept of embedded claims, in this case to a worldwide license, in a way which it wouldn't be appropriate to think that it would do outside that intellectual property field, the intellectual property field being so uniquely geographically based, because patents are geographically limited beasts.
Well, I'll submit on that in the day, you may recall this court's decision in Lucasfilm and Ainsworth. Lucasfilm and Ainsworth. That was the decision that held that some of the territoriality restrictions as to subject matter jurisdiction were more fluid than they'd previously been thought. Before then, it was thought that you couldn't get infringement claims at all as to foreign patents, but that changes after Lucasfilm. But the point is the presumption of territoriality being deeply embedded in intellectual property law for centuries. And what I would submit, and that would be the assumption and the basis on which all these rules were created, and well, I submit to your proposition to be there, is totally inconsistent with how any intellectual property lawyer reading Part 63 against the background of the presumption of territoriality would have construed it. He would regard that, or she would regard that, as an artificial results-oriented construction which has no basis in the words or their purpose. So, my lords, it's also worth noting how dramatic and rigid the jurisdiction being created, the one patent out of thousands point. If we consider Gateway 11 and 6314 together in their legal and historical context, there is no basis to infer that it was the purpose of the legislature to create a wide jurisdiction over what is in reality contractual claims as to foreign property, nor that it was intended to permit a device like the Vessel logic to achieve this. Instead, Tesla's case is precisely the sort of claim, connected only in very small part to UK property, that the Rules Committee positively did not intend to be covered. And is this one of those cases where what the Rules Committee would do would be a foregone conclusion? No. You will be aware that there is, at the moment, considerable debate as to whether the UK courts are pushing at the boundaries of comity in relation to territoriality. There's considerable concern internationally. Now, Unwired is, because of the accident of relief, pushes quite hard towards the boundaries of jurisdiction. But the idea that the Rules Committee would automatically, were it asked to legislate, create a rigid jurisdiction like 6014, where you've got one patent in the UK, is very implausible, we would submit to you. And also, to construe these rules in that way would be a purely legislative act. Those are my submissions on 6014 and Gateway 11.
Thank you.
I was going to, unless there's further questions, though we do have time constraints, I was going to turn on to serious issues to be tried and real prospects of success. In response to a question from Lord Burrows, just to clarify how this works for 6314, we brought a strikeout in the alternative, and the merits test is the same. And so, in relation to the 6314 claim, Bancourt J struck that out, and that's paragraph 103 of his judgment at 329. On serious issue real prospects, there are 4 points. Firstly, the ground 2 issue, that the licensing claims can't be heard in the absence of others. Secondly, that there's anyway no proper claim against Interdigital. Third, even if there's a proper claim against Avancee, it's inappropriate to have Interdigital as co-defendant and wholly unnecessary. And fourthly, the ground 1 issue, the Frand into the pool issue. Now, on ground 2, it's important to understand what this claim really is about, because this affects some of the exchanges that I heard yesterday between the court and Mr. Nicholson. Tesla's claim is just the terms of an Avancee license, nothing else, but it accepts it has no cause of action against Avancee. So to deal with that, it engages the Etsy undertakings of all the licensors. I've taken you to the pleading where that's plainly what it does.
But I mean, not as the argument is now framed. I can see that it was there in the pleading, but as I understand it, the argument is now framed is there's an Etsy obligation given by Interdigital, and that's the foundation for the claim.
But you simply can't find that in their pleading. It's just not their case. Their case is, as you've seen quite clearly in paragraph 58, to engage all the Etsy undertakings together. The redescription that's attempted is artificial. It's not the substance of what's going on. Now, and that also is unsurprising, my lords, because that's what they need at trial. Interdigital cannot give the Avancee license. Interdigital cannot procure it. Only a very high percentage of the licensors, that's at paragraph 61 of our written case, can do so. You also have to have all those who have a blocking share to do so. So Tesla absolutely needs, in its claim, to get something, a finding that all licensors are obliged, otherwise it wouldn't work for them. A declaration as to individual obligations alone wouldn't work and makes no sense.
So when you say it wouldn't work, I mean, they're just seeking a declaration that the rate is not Frand. I mean, if they get that, that works for them. They have that declaration. That means that Interdigital, if Interdigital are seeking to enforce their SEP in due course and are seeking to rely on the availability of a license over the platform, wouldn't be able to say that that is sufficient to enable them to enforce their SEP.
But all those points, my lord, are artificial retrospective confections, because that is not what they want and not what they are claiming to achieve. They don't want to shut out infringement litigation by Interdigital. No one's ever suggested that's remotely relevant. It's an artificial confection. What they want is a declaration that will enable them to get a changed license from Avancee. In a sense, it's a question of how much artificially...
But they don't seek it in the sense that they're asking for an order by way of specific performance for a changed license from Avancee, or even an order against all the SEP owners. They simply say that if we get that declaration, then in the commercial world, that's what will happen, and therefore the declaration has utility.
Yes, but also the claim for specific performance will be added by amendment the next day. Now, even... So the reality here is they want to get a claim as to everybody's obligations because they wish to procure the license. If this had been framed as a claim just as to what Interdigital is obliged to do, Avancee could ignore it very easily.
Sorry, could ignore it?
Avancee could ignore it. That would just be irrelevant. It wouldn't be a declaration as to what the other licensors had to do. But here they seek a declaration as to everybody. And it's central to what they've been doing from the beginning. Now, it is not this court's job.
Sorry, in a sense, Avancee could ignore it. I mean, Avancee doesn't need to participate in the claim against Interdigital. They wouldn't be bound by the finding themselves. They could still use their platform in China and elsewhere around the world. But just that they would be practically vulnerable to SEP owners being confident that they could enforce their SEPs in the United Kingdom.
Well, it's more than that. If the declaration is made as to the obligations of everybody, which is what is claimed, then the reality is it will be untenable if that declaration is made against Avanci, which of course is what is sought, because they seek to bring in Avanci by Gateway 3, and that would follow. The purpose is therefore to produce the result where Avanci cannot practically do anything other than change the license. Because there's a declaration as to everybody, not just Interdigital, that the current terms are inconsistent with FRAND. And that is what is sought to be achieved, my lord. And you should not forget here also that FRAND terms are not abstract, but depend on the relationship and conduct between the parties inter se. The references to that are Lenovo and Ericsson, paragraph 20 at 2007, Panasonic and Xiaomi at paragraph 212662. So that will vary for each licensor. In particular, Tesla has a bilateral from the single biggest licensor, L1, who does have a blocking share, softly paragraph 14. And that will obviously affect what's FRAND for it.
Sorry, could you just make that point again, please, for me?
Tesla has a bilateral from the single biggest licensor, L1, who does have a blocking share. They need that declaration against L1. That's softly 14. And that, therefore, that license...
Sorry, they're not getting the declaration against L1.
Yes, they are.
In what sense? I didn't think L1's not a party, are they?
They are seeking a declaration against Interdigital as to the obligations of L1. Well, if this is difficult to grasp, it is really because of the sheer absurdity of the nature of what is being attempted against Interdigital. It's almost strange to think, how on earth can it be the case that they're claiming as the obligations of everybody against Interdigital? It makes no sense. Once the representative claim had failed, Tesla's claim became nonsensical, and therefore...
I'm sorry, I don't follow why it's nonsensical, because, I mean, Interdigital own their own UK SEPs.
Yes.
So I mean, if Tesla launches its products on the market in breach of Interdigital, even just one of Interdigital's patents,
yes,
Interdigital can completely stop that.
Yes. But that's not what they're about. They are wanting a license worldwide for everyone. There is no basis to suggest in any way that Interdigital intends to sue them for infringement. It's never been suggested. And, my lords, it's not your job, we would say, to identify a different way Tesla might have run a claim that might have presented different issues. And it's not your job to dig within a pleading that's fundamentally wrong and extract from it something different. That's my suspicion of what these questions are achieving. In reality, you look at this claim with all its deficiencies, and you ask, what does it do? Well, the second point, and this is crucial also, above the obligations, is the purpose of Tesla's claim is to affect obligations and interests of all licensors. You were taken to Brody 3, paragraph 39, page 593, where she made it clear that it's common ground that a declaration against Avanci, holding a license to non-FRAND, would make it untenable for Avanci to continue to offer the same. It could pressure licensors to issue revised terms and the like.
But isn't this the position? Tesla's claim,
Yes.
rightly or wrongly, and we're only here concerned with arguable case,
Yes.
proceeds, I think, on an almost unspoken assumption that if the platform license isn't FRAND quo ad Interdigital, then it isn't FRAND quo ad any licensor. Because whether or not it's FRAND is something you get at by looking at the license as a whole and not asking the question separately in relation to each of the 80 or 90 SEP owners whose SEPs are being licensed under the platform.
Well, may I take...
Now, that may be wrong, but that as I think I've read the pleading, that's the unspoken assumption.
Well, may I take you back on that? Because no, that is not what is going on. What is being claimed is a declaration against Interdigital as to the obligations of everyone, and so what is FRAND for everyone. That is the claim.
Well, but that is the...
And it's not,
am I wrong in making that assumption? That's
Yes,
how
you
they
are.
approach it.
Yes, you are. Because it is true that if a claim was made against Interdigital alone as to whether it could discharge its FRAND undertaking by a pool license, that you would then be looking at the FRAND position of Interdigital by reference to its portfolio. But that is not the claim. The claim is as to, quite clearly, paragraph 58, paragraphs 40 to 41, paragraphs 1 and 2, to get a declaration as to the FRAND position of everyone by way of picking Interdigital as sole defendant out of the blue. And that's the fundamental point, my lord. Now, again, you can identify possibly a different way of making claims, a different pleading, which would have different problems, but that is not what is being brought in.
But I mean, doesn't that just, if I may say so, reflect the assumption that my lord was putting to you? So it's true, in a sense, they picked on Interdigital, but Interdigital do hold UK SEP, so it might be said a legitimate target, just as any UK SEP owner would be. Yes. They want to test the question whether availability of a license on the platform meets the FRAND obligation to which Interdigital is subject. They are making the assumption, because all UK SEP owners who are on the platform are offering the same license, that if they get a ruling in relation to Interdigital's position, since one can't see a relevant difference, at any rate at the moment, between Interdigital and any other UK SEP owner, that a ruling against Interdigital will have implications, not necessarily legal ones, because other people won't be bound formally, but practical commercial ones in respect of all other, first of all, UK SEP owners on the platform, and then, by extension, all SEP owners on the platform.
Well, with respect, that assumption is not what is pleaded. Can I take you back to paragraph 58 of the particulars of claim?
Page?
At 358. Accordingly, Tesla is entitled to enforce the FRAND commitment of each Avanci 5G pool member, including Interdigital, by seeking a license from and or through Avanci covering the entirety of the Avanci 5G pool. And likewise, it's the same for declarations 9 and 10. Well, let me give you one of the reasons why they didn't do.
But I mean, they plainly haven't joined all the 5G pool members.
No.
So, I mean, this isn't describing the claim in the formal sense of what am I entitled to against the other party to the litigation. It's describing a consequence if they make out their claim against the other party to the litigation.
Well, Lord, no, because what they are seeking to have declared, and this is the fundamental paradox, this is why they began this as a representative claim. They are not seeking a declaration of Interdigital's obligations. They are seeking, quite clearly, a declaration as the obligations of everyone. And let me tell you why that matters. I mean, it's not for me to come up with some better way they could have claimed this. But, for example, if they were to have described the claim the way that your lordship suggests they should have, if Interdigital then withdrew from the platform, which it could do, then the claim would fail not just against it, but against Avanci. And they don't want that.
Well, that's Interdigital's course. They either do or don't stay in the Avanci platform.
It is, but my lord, the point is, this claim is not constructed to fail if Interdigital withdraws. This claim, if you allow jurisdiction over it, will create declarations against Avanci as to everything, whether or not Interdigital has withdrawn. And Lord, that exposes the unreality of the assumption.
But that's only if Avanci comes in.
Yeah.
But Lord, obviously Avanci is going to come in.
Well, yes, they are, but that's not the nature of the claim that's being brought.
This is a single claim. A single claim making the same cause of action against both parties.
But hold on, but shorn of the representational basis,
Yes.
which they are shorn of because it's been disallowed and they haven't appealed it,
Yes.
this is a claim against Avanci, which, if it can be pursued against Avanci, will be defended by... Sorry, a claim against Interdigital, which, if it can be pursued against Interdigital, will be defended by Avanci.
Because they will come in as necessary and proper party.
Because they said they'll come in and defend.
Well, whether or not they're a necessary and proper party, that they want to come in and defend it. They have commercial interest to do that.
Yeah.
They do. But all that exposes, my lord, again, the reality is, and this is why we come back to the difference between this situation and Nexus. Now, you'll recall there was a discussion of Nexus, paragraph 58, and in Nexus, there was this short sentence where the Supreme Court said, among other options, one thing that could happen is you could have a claim against a single employee or group as a sort of test.
Yeah.
But more, that is an entirely different claim, because in that situation, you'd be getting rectification or declarations against one employee as to its rights and obligations and the rectification of its employment contract. Now, in the way that test litigation does work, that would then be used to have influence on everybody else. You would hope, that's why you do test claims, that everyone settles around it. But the others would not be affected in any way directly. They could pursue their own you could pursue their own defences. They could say,
if you're not bound by the order,
That's right.
in the next claim, you can run all the same arguments.
That's
It
right.
may be that you face difficulties if you've got a court ruling, but courts sometimes disagree with each other.
And that's therefore the fundamental difference here, because what was envisaged in Nexus is a claim against X as to X's rights, whereas here, what is being attempted, now the representative claim has failed, is a claim against Interdigital as to everyone's rights, and that is directly pleaded.
Well, I think it's going to be said against you. No, it's a claim against Interdigital as regards Interdigital's rights. It may be that a ruling on that has knock-on commercial consequences for others.
Particularly if Avanti comes in.
Yeah.
Well, now, but well, this, well, I'll simply ask you on that to go back again, read the pleading,
Yep.
look at what is actually claimed, and ask yourself the reality of this and why it is done that way, and to, if I may, emancipate yourself from the assumption that there could be another way of doing it which would be more logical, and look at actually what is claimed and why that is claimed, for which there are real reasons. Now, moving on then to...
I mean, just in terms of the form of the pleading, might it not be said that that was put forward at a time when Tesla was, in effect, hoping that it would get a representative?
Well,
Yeah, but they've never amended.
it was originally put on the basis that because Avanti was acting as agent for all the SEP owners, and they all owed ETSI obligations, they could sue Avanti directly. Now that's gone, it's been rejected, and I don't think it's now being pursued.
No, it isn't.
And nor is the proposition that Interdigital can be treated as representing all the SEP owners. So that, in a sense, paragraph 58 is no longer there in full force. It's been largely crossed out. As I understand it, what they say now is that it is useful for us to get a declaration that quo-ad Interdigital, this platform license, is not FRAND. And also, if they can, a declaration as to what would be a FRAND platform license quo-ad Interdigital, because Avanti is going to come in, it will be bound, and it will be highly effective as a test outcome so far as all the other SEP owners are concerned, because they say, actually, if it's not FRAND quo-ad one lot of SEP owners, it's not FRAND quo-ad any of them.
And in pleading terms, the pleading was cast wide for the reasons that my lord has said, but it also comprehended the claim that we're now focusing on. No one said that claim hasn't been pleaded. Yeah. So other things have stripped away, and we're left with the claim by Tesla against Interdigital. And it's pleaded. Other things are pleaded as well, and you're pointing to some features of the pleadings which may have been driven by other aspects of the claim as it was originally framed. But I mean, you're not saying, I'm sure you're not saying that the current claim that we're focusing on has not been pleaded against Interdigital.
I am saying it, my lords, and to answer
Right.
Lord Briggs' question, I can ask you to turn to the current draft amendment
Okay.
at page 971.
971.
Yeah. And the point you're putting to me is not that. The very thing they maintain is paragraph 58. the very thing they do not drop is paragraphs 9 and 10.
Well,
It
may still be there, but they have been told they can't have it as a matter of legal right against Avanci, and they haven't appealed that.
Well, again, you're misunderstanding, if I may, what they're doing. They have accepted they have no legal right against Avanci, which is why they have dropped bits of 57 and 59, but they maintain their claim based on 40 to 41 as to the ETSI commitments of everyone, and then 46, the ETSI commitments of everyone, and they maintain their claim at 58 to enforce the FRAND commitments of everyone by seeking license from Avanci. So there is nowhere a distinct claim as to the obligations of Interdigital. And you can also see this from paragraph where they deal with the rates. Go to paragraph 31 to 32 on page 964. The only thing they want is particulars of the terms of the pool license. There is no claim to say, if you, Interdigital, offer us a pool license, of course that's totally unreal, as something, anyway, not grounded at all. If you do that, then that will be non-found in these particular ways. So you just have to understand, the difficulty maybe is quite how far-reaching, how ambitious what they're seeking to achieve is. And once the representative claim has failed, this does fall apart, and that is why we strike it out. Now, if they want to come back with some different claim about Interdigital alone, then we would have different arguments about it. We could say premature, for example. We could say we're not infringing. Who knows what we might give by way of undertakings in that context? Who knows whether we would just withdraw from the platform or whatever. But that is not the claim we face. And that is not an accident, my lords. Now, then, and it's for that reason that our ground 2 point, once you understand this, is so forceful. It's all about the characterisation of the claim, of course. That's for your lordships to decide. But we submit you should look at realities, and not at a different way they might do it that might have different problems but isn't before you. Now, it's also worth spelling out a bit more closely precisely why there'll be such an injustice in this case if this claim proceeds. Because there may also be misapprehension here that it's just about the evidence on the platform rate. But it's not. What's going to be engaged is the rights and obligations of all the licensors as to FRAND as well as to rate, as to what their positions, for example, may be as to how they deal with pool licensing, what they regard the scope of their FRAND obligation to be, also their FRAND conduct, the point I already made to you. So it's both. And there's also, of course, the rate. What would that rate mean in terms of all the others? It means a valuation of all their portfolios. It has
Valuation of?
All their portfolios. Each of their portfolios is probably a better way to put it. Because the only sensible way to say, as to everybody, have you discharged your FRAND obligations, of course that's a claim against Interdigital, would be to assess the pool platform rate as against their portfolios and the value of those portfolios. Now, I provided you yesterday, I hope you've got it, the current picture, it should be on the portal, of the Avanci website, which gives 85 plus licensors, and I've given you a list of the names. If that's not easy to find, we can get it to you. But it's basically almost all the major players in this field. The proposition that all those players would have nothing to contribute to a claim about the 5G stack and their FRAND obligations in respect of it is absurd. These are people who have very strong views on these matters. They've been fighting, many of them, about exactly these issues, their respective valuations, who is a net payor in the cross-licensing cases, in all the FRAND litigations littered over the reports for years. And so what the essence of this claim is to say that all of that can be tested against Interdigital. And that is something that they would all have their perspectives on, that they would all have their cases to meet, to advance. Now,
where is this argument taking you? Because, as I understand it, you accept that all that would have to be done if we were dealing with an actual infringement case.
Well, the question that Lord Briggs asked about what happens in that sort of situation is very important. I'm going to come to that.
All right.
Now, in an attempt to deal with these problems, Lord Justice Arnold speculated about various ways that some of these problems might be met. For example, you might do representative comparables or doing a top-down analysis. But the short answer to all of that is, firstly, it's surmise and Corberism, and secondly, that it's all second bests. None of it comes close to the positions of these people being defended in the way they would defend it.
But there's nothing to stop them coming in, is there?
I'm going to come to that point.
Oh, good.
It's a very important point again. Now, the next point, before I get to that point, is the idea that this can all be dealt with because, well, don't worry, Avanci will help out behind the scenes or maybe be joined. But those ideas are circular because for the purpose of testing whether there's a proper cause of action against Interdigital alone, as Mr. Justice Fancourt said, that's paragraph 80 of his judgment, you have to ask that independently on its own. The authority for that is Erster, which is at page 1597, paragraph 38. So it's a circular proposition for asking whether there's a proper claim against Interdigital. Secondly, it's just not an answer in any event, because there's all sorts of ways Avanci can't deal with this. Firstly, this is, again, you look at the obligation side. This is about not just rates, but about the FRAND obligations of all the licensors. Avanci can't deal with that. Secondly, Avanci won't have all their information, doesn't have their comparables, and even to the extent it has stuff, it can't defend their portfolios in the way they would defend their portfolios. Indeed, quite the reverse. The evidence of Ms. Rajendra, paragraph 9, page 505, is that Avanci is not seeking to maximise the value of the stack. It is seeking a compromise between licensors and licensees. So the idea that Avanci could effectively defend all licensors is fictitious.
Can you just remind us, this is Mr. Rajendra, is that?
Ms. Rajendra.
Ms. Rajendra,
Avanci.
It is Avanci, right.
That's right. Now, the next point to address is Lord Briggs' suggestion that the licensors might choose to join and this could fix the problem. Well, if I may, that proposition proceeds on a false premise as to the nature of the nexus principle. And false premise is that nexus is just about protecting the other parties. But it's not. The point is, it is inherently inappropriate from the perspective of the court, from the perspective of the existing defendant, as well as the other parties, to make a declaration in the absence of others. Because the court cannot properly make that declaration. And once you understand that, the speculation, and it's no more than that, that other parties might come along and join, is not an answer. They might not. And if they don't, the court is left with an inherently inappropriate claim.
Well, it's not inappropriate. It needs to be resolved as between the parties. It's just that whatever the court does won't bind people who aren't parties.
And also, when it gets to the detail,
Yes.
the court may conclude that the unspoken proposition that if it's not FRAN quoad Interdigital, it's not FRAN quoad any of the SEPs, is just wrong, in which case the whole thing may collapse. But we just don't know at the moment.
Indeed, but the point is, though, the very, very short point is, what are they asking the court to achieve, and what would happen if they win? Because you can't say, oh, don't worry, they might lose. You have to ask whether the claim is inappropriate. And the claim is to determine the rights and obligations of everyone.
Well, it isn't. You say that. The claim in terms of English law procedure is just to determine the rights and obligations of the parties to the action.
No, my lord, if I may, it is against a party, but the claim made is as to the obligations of everyone, and you just have to read the pleading to see that.
Right.
That is why it's wrong.
I mean, I think we're going around the house a little bit. Any ruling by the court will not bind people who are not parties to it. It may have commercial implications for them, which one can well see, and I'm certainly not saying that they wouldn't be entitled to ask to come in to be joined in order to protect their real-world interests. Yeah. But in terms of procedure, whatever the court did would not bind them if they weren't a party.
But then, of course, you have to understand, and this is why nexus, and particularly the formulation given by Lord Justice Phillips, is not just about determining rights. It's not just about res judicata. It's also about attempting to determine issues as to them in ways affecting their interests in their absence. And of course,
but the law about proper parties has never been so wide as to say you've got to join everybody whose interests might be affected. Yeah. I mean, for example, you can sue trustees of a piece of land with a dispute about legal ownership of the land. Yeah. No doubt that will highly affect the interests of all the beneficiaries, but nobody's ever suggested they have to be joined as parties.
I mean, everything is case by case, but it's very clear in this case what is being attempted. Also, just picking up on the inappropriateness of the joinder proposition. What is being attempted is to bring a claim against Interdigital as to the rights and obligations of everyone, so as indirectly to force other people possibly to come along. But that in itself is wrong, because it is wrong to claim against X, not to claim against Y, as an indirect way to force Y to come along. And that's particularly wrong in the jurisdiction context, where by doing so, those Ys will be submitting to the jurisdiction. Now, that then takes me, my lord, to the other important question that you raised with my learned friend, Mr. Nicholson, which is, well, how does this work in the SEP holder situation? What happens if a licensor voluntarily relies on the platform license in purported discharge of their ETSI undertakings? Would that require joint of everyone? And the point that was put to Mr. Nicholson, well, if it did, that's something of reductio ad absurdum of the proposition that we're running. And my lord, I think Mr. Nicholson may at points suggested they would need to be joined in the SEP holder voluntary case. But we disagree. Now, again, the discussion on this has been flawed, with respect, by a misunderstanding of the differences between the claims. In the SEP holder voluntary case, where they say, I'm going to use the platform license in discharge, the SEP holder is taking a license and saying, that satisfies my FRAND obligation over my portfolio. He's not attacking the others. He's not necessarily engaging the rights of the others in the way Tesla is seeking to do here. Nor will the implementer's defense be attacking the others. The implementer would just be saying, that doesn't satisfy your FRAND obligation over your portfolio. And those two things are relative, because whether a platform license satisfies a FRAND obligation of, say, Huawei, depends on Huawei's portfolio. It's not the same thing at all for other licensors. Now, as a result, you have a very clear contrast. In those situations, you could have litigation between those two. Nobody else would have to be joined. It would not be inherently inappropriate for either the SEP holder to raise that declaration, nor for the implementer to defend. But that's because there wasn't an attack. Whereas here, the whole point, and it comes down to this, how you read what's going on here, the whole point of Tesla's claim is to attack the platform as a whole, using Interdigital as a hook, and a wholly irrelevant hook, a hook that has no business being here. Describe it to my team as an innocent victim of a drive-by shooting. But that is not, they are not here to get a claim against Interdigital. They're here to get claims about the platform and to attack everyone as a whole and to produce declarations which, one way or another, whether by way of res judicata on avanci, whether by way of the pressure that creates on the licensors to vote for a change, changes the terms. And that is why this situation is so toxic, and that is why it is totally different to the implementer situation, and that is why here everybody needs to be joined for this claim properly to be brought.
But that still takes us, I think you're going to come to the question, well, what happens if one SEP owner brings infringement proceedings? Because the defence would do exactly the same thing, except that the one SEP owner would have sort of offered himself as a hook by bringing the infringement proceedings.
Well, I think I've just answered that, if I may.
Well, I'm not sure you have.
Well, I'm probably going to do it again then.
Because I think you're saying that it would still be an improperly constituted action.
No, not at all.
Even if it's a defensive response to an infringement claim.
No, not at all. It would be absolutely, there'd be nothing wrong with it. Either way.
Even though it would attack the platform as a whole.
Well, firstly,
using the infringement claim as a hook.
Well, no, because what the implementer there would be doing is saying something very limited, which is you, Huawei, Nokia, Ericsson, whoever it may be, you cannot get an injunction against me just by offering a platform license, because that platform license is not a satisfaction of your ETSI undertakings. So the only question being raised is whether that platform license addresses and meets the ETSI undertaking over that portfolio, not over the portfolios of others.
Right.
And as a result, it's very different to this claim.
But that assumes an outcome to the question, is the question whether it's either FRAND or not FRAND, quote anybody who's ETSI any SEP owner who's given an ETSI undertaking, i.e. whether it's in fact differential in the way you say. You may be right, but we're only at the arguable case stage.
There are, of course, there will be, issues might be determined a principle in that case, which could be of interest generally. But the core difference, I ask you to focus on what is being attempted here, is in that case neither party will be trying to attack nor seeking claims as to, express claims on the face of the pleading as to the obligations of everyone else.
Well, they may or may not do.
Well, if they did.
Because if it's legitimate for the implementer to respond to the SEP owner's infringement claim by saying you've offered a license in discharge of your ETSI obligation, it doesn't discharge it, we say, then that has to be tested, and it has to be tested even though it may have knock-on consequences in relation to the operation of the platform generally, and even though the motivation of the implementer happens to be, well, I don't like the way the platform's working, more generally than I just want to defend myself in this case.
Well, that's an important question, and our answer to that is this. If you look at this defence, and let's imagine a defence and counterclaim, that's probably the clearest way to look at it.
All right.
And if the counterclaim was just saying, I want a declaration that that claim, that license that's been put to me is not a discharge of your SEP undertakings, and that counterclaim did not purport or seek to create remedies against and rights against others, then the counterclaim would be in the position I've put to you already. It wouldn't create the same problem here. But if the counterclaim was a counterclaim seeking to bring in avanci by way of defendant to counterclaim, and was essentially not just fighting about the issue between that SEP holder and that implementer, but was seeking to do, basically, by way of counterclaim, everything that's claimed here, that very different situation, and they are totally distinguishable, then one can imagine that similar arguments to what I'm running here might run. But that would be very different to what's inherent in a simple SEP holder claim. Lords, I do have to move on, but that is my answer. Lords, that then takes one to the separate point that there's no proper claim against Interdigital anyway. Now, we've set out the authorities in our written case, 40 to 42, 59 to 60.
I'm sorry, I missed those references.
Paragraphs 40 to 42 and 59 to 60.
Yes, thank you.
And taking it shortly, a couple of important points. It's not right to say that the only issue is useful purpose. There are other principles in play. For example, hypothetical declarations can be improper in principle. This is a structured discretion. Also important, and this is a case, this comes out of the TQ Delta case at paragraphs 50, page 2887.
2087?
2887.
2887.
If the utility is disproportionately small compared to the burdens and cost of litigation, that can be a reason in principle not to grant litigation. And also as a matter of comity, you can't get FRAND declarations which are really about not dealing with UK issues but trying to prejudge infringement litigation abroad. And that's at 52 of TQ Delta at 2887 as well. We'll then stand back and look at the facts of this case. What Tesla wants, that's held by both Fancourt J and the Court of Appeal, it's paragraphs 9 and 58, Justice Fancourt's judgment, paragraphs 241 and 246 of the Court of Appeal's judgment. And those are factual assessments of what the claim is, which this Court shouldn't be interfering with. What it wants, what it really claims, is a revised Avanci license. But Interdigital can't grant that, only Avanci can. Interdigital can't prevent a revision. It's got far too small a share of the platform to do so. That's the first point. Second, this isn't really a fight with Interdigital, which was sued out of the blue after negotiations between Tesla and Avanci, which it knew nothing about. Tesla has given no coherent reason to attack Interdigital at all. It's never identified any threat of infringement litigation by Interdigital because there is none. On the point that Interdigital hasn't offered undertakings, we set out the authorities at paragraph 70 of our written case. You cannot create a list without any basis of a threat at all, any basis of a claim at all, by saying, oh, you haven't offered an undertaking. Mr. Alexander is not entitled to a declaration against me that I'm not going to hit him, shouldn't hit him, and then say, you haven't undertaken not to do so. This is because one doesn't get declarations as to hypotheticals. Thirdly, Interdigital take no position on what the platform rate should be, had no role in setting it, and doesn't rely on the Avanci license as discharging its Etsy undertaking. And its uncontradicted evidence, Brodie 2, paragraph 45, page 521, agreed with Hopewell 3, paragraph 70, 564.
I'm so sorry, that was a bit quick on the references. Can you just give those again?
Brodie 2, paragraph 45, page 521, not disputed, Hopewell 3, paragraph 70, 564. That says it can't even assess the platform rate, which it can't. Fourthly, declarations against Interdigital alone would be ineffective. They would not bind the rest of the licensors or Avanci who would likely ignore them. Fifthly, the cost of litigating this would be vast, in the tens of millions, which create a wholly disproportionate burden on Interdigital. That cost would be far more than any revenues Interdigital would ever get via the platform in respect of Tesla, and yet more vastly greater than any difference Tesla's claim might make. And the reference there, Brodie 2, paragraphs 48 to 49, page 523. 523, my lord.
Thank you.
Well, all this led to Mr. Justice Fancourt rightly finding on these facts that declarations against Interdigital alone would not be fair and just. He also referred to the powerful point already made that Interdigital cannot properly address the cases of the other patentees. Paragraphs 99 to 100, and cannot properly defend the rate as the platform. He made no error of principle, and this court should not interfere. And that leads also to Lord Justice Whipple's conclusion that a declaration would not serve a legitimate purpose given, and I quote, paragraph 254, page 299, would not serve a legitimate purpose given the poverty of Tesla's case set against the potential time, cost, and complexity of the proposed litigation. So we submit that when you put those facts together, it is clear, and it has to be shown that it's freestanding, it's circular to assume Avanci would be there, that there is not a proper claim against Interdigital alone, because of the simple unfairness against Interdigital. Now, to deal with these problems, there are attempts to confect retrospectively utility that is not Tesla's purpose. So it's said it'd be useful to determine in abstract, this is, I think, the burden of some of the questions from the court, from my Lord Sales, it might be useful in abstract to determine what might be Fran for Interdigital's portfolio. But that's not what the claim's about. It's about getting at the license from Avanci. Tesla accepts, of course, that it needs a license worldwide, particularly to claim 44 footnote 7. The whole claim, as you've seen also for paragraphs 1 and 2, is about getting at the license, but using Interdigital as an innocent hook. But by doing so, imposing a massive burden on Interdigital. And some suggestions something made that this is Interdigital being obstructive, trying to protect the platform. Not so. Interdigital does not see why it should have to spend the tens of millions that would be involved in being attacked in this way. And this is why also ground 2 is not just legally right, but commercially right. Were there a claim against everyone, it wouldn't be such a bother. A bother is a small word. Interdigital could just sit back and let others fight. And others may have much more aggressive stances or interested stances in relation to all this. Interdigital takes no position on the rate and says it can't assess it. So, once again, we are not seeking by this to create some immunity for the platform. We're just saying, not us. Leave us out of it. And if they want to do some other claim that works in a different way against different people, they can. But don't hit us as the sole target. Now, Mr. Alexander suggests there might be utility to other licensors and licensees. That's not a useful purpose for Tesla, and it's no reason to bring this claim against Interdigital, imposing the burdens on it that are imposed. And finally, Lord Justice Arnold suggested that a declaration against Interdigital, even if not binding on others, might cause Avanci and or the other licensors to reconsider their position by some form of persuasive effect. But we submit that's not a legitimate and useful purpose of a claim against Interdigital on its own, imposing these massive burdens. And that's where I repeat the point made by Lord Justice Whipple. That deals with NITP ground 1. The final point on this limb, which is equally important, is that if Avanci is a defendant in its own right, you don't need Interdigital. Now, there was an exchange between my Lord Briggs and Mr. Nicholson as to, well, why do we need a legal right against you to make a declaration against you? I'm not going to engage with that. That's a matter for Mr. Nicholson. But assume your lordships are against Mr. Nicholson on that, and assume that there's jurisdiction by Gateway 11 against Avanci, and assume that it is possible to make a declaration against Avanci in inherent jurisdiction independent of a legal right against it, essentially on the basis that Mr. Alexander puts you, that it's acting as the agent of all the licensors. Well, look at that claim. Do you need Interdigital as a defendant? And we say, no, it'll work just as well against Avanci on its own. If we've had the debate already about whether you can deal with this on the basis of Avanci's evidence alone. If that's true, you don't need Interdigital. If it's false, you need all the licensors. And so Tesla here is in a fork. Either, they can make this claim work against Avanci alone, or they have to be suing everyone else. Because what there isn't any basis for is to say we need Avanci and 1 out of 85. We make no difference. We make no difference evidentially, and we make no difference either in terms of the practical effect on the platform because of our tiny voting share. of course, the Supreme Court is interested in matters of principle, but we are interested in our position. We are interested in whether we get sucked into this litigation, which is not our concern, to defend on our own, or as the only licensor there, having to deal with claims as to the rights and obligations of all the licensors, at massive expense to us. That is what we are concerned with, and we say that is wrong. And so it is a practical solution for Interdigital's concerns, if there's a proper claim against Avanci, for Interdigital to be left out, because there is no incremental additional utility raised by this claim by adding us that's sufficient to justify putting the massive costs and burdens on us. Now, it is said sometimes, well, if you're not really going to participate, if you're not really going to fight the rate, well, what's the problem? You can just sit there. But that's not a good point. Just consider adverse costs risks. Consider all the issues that might be raised against us. So, well, that very short practical point is an answer to the whole claim against Interdigital. Well, that takes me then to the matter of principle as to whether the platform license is obliged to be FRAND. Now, I'm going to focus, there's a lot of debate between the Court and Mr. Nicholson on that. I'm going to focus only on two narrow points. While making no concessions, I'm going to assume that it's arguable that a SEP holder can voluntarily rely on the platform license, the point that was debated with Mr. Nicholson. I'll assume that for these purposes. We then take 2 points. Firstly, licensors are not obliged to offer the platform license while in the platform, so the platform rate doesn't have to be FRAND. And secondly, there is no useful purpose in hypothetical declarations in abstract against Interdigital as to what might happen if another licensor might voluntarily rely on the platform rate in discharge of its ETSI undertakings. The argument on the first point, this is the only point, is a short but decisive. We adopt the Court of Appeal's reasoning. There's no sensible interpretation of the ETSI undertaking that requires the SEP holder to license the patents of others or to license collectively. Further, even if that could be conceptualized as an abstraction, as Lord Justice Whipple said, paragraph 245, no basis for such an obligation is pleaded, nor is any basis in French law identified for such an extraordinary proposition. And Tesla can't get away with not putting before this court its own French law evidence below, which did not make out the case, otherwise they'd have put it before you. And none of this is an accident. It may well be that Tesla's real case is in competition law, but it knows it would have difficulty in fitting a competition law claim through gateways. So to the Court of Appeal's reasoning, we then add 3 points. First, we know from Unwired, paragraph 121, page 2961, that there can be more than one FRAND set of terms. So if a bilateral is FRAND, licensors can discharge their ETSI undertakings by choosing to be prepared to grant a bilateral and not anything else. And that's what we, Interdigital, do. So Tesla can only succeed in imposing an obligation on Interdigital if only a platform license can be FRAND. But that's an extraordinary proposition for which Tesla identifies no basis. They accept, 44 of their written case, that FRAND doesn't require everyone to join a platform. They accept also that licensors can leave the platform. That's Hopewell 3, 52K, page 558. And the MLMA expressly allows them to do so. Any contrary conclusion would be an extraordinary interference with contractual freedom. So what that means is they have to say that somehow the fact of being in the platform transfers the ETSI undertaking means that a bilateral cannot be FRAND. But there's no basis for that in law, in terms of the undertaking, in evidence, or in logic. It contradicts the natural reading of the ETSI undertaking, which says you've got to be prepared to grant a license over your SEPs. It also makes no logical sense. The same license would be FRAND as the same portfolio if offered outside the platform. But somehow it said that being in the platform and also offering something easier in certain dimensions somehow makes something that would be FRAND were you not in the platform, unFRAND. And how can that follow? The argument seems to be something to do with commercial practice, that somehow being in a platform means that it's kind of difficult to do the bilateral thing. But there's a confusion here. Whatever may be the case about whether it's difficult to get licenses from everyone in the platform, nothing about the platform makes it difficult to take a bilateral from Interdigital. That is as easy as it ever was. There's not a shred of evidence to suggest any difficulty in getting a bilateral from us. And further, as a matter of commercial practice, it's utterly common for licensors to bilaterally license alongside platforms. We've set out the evidence on this in paragraph 22 of our written case. Many of the licensors on the platform have bilateral programs. Tesla itself took a bilateral from more than one person, and the MLA expressly allows bilateral licensing. So how is it then that some commercial practice transforms the ETSI undertaking to make the bilateral non-FRAND? And not only is there no evidence as to why this is in any way difficult from any individual major licensor, it's also incoherent when one stands back and considers the function of the ETSI undertaking. The baseline, at the very least, of the ETSI undertaking is bilateral licensing. That's where you start from. Embedded in that is the inherent difficulties, to the extent they exist, of bilateral licensing. That's the whole structure of the process. That is the assumption from which you start as to what is FRAND. That, for example, in the cellular world, outside automotive, that's what always happens. You cannot make that non-FRAND by offering in some limited field a particular, better advantaged structure that in some ways is more convenient because it was FRAND to start with. Consider also the conceptual difficulties of cross-domain licenses, something that's not just automotive, but is outside in all sorts of fields, including automotive. Is that somehow prohibited by the existence of being in the platform? The argument collapses once you test its logic. So, yes.
Are you simply attacking their submission that, which is part of their case, that there is an obligation that the platform license should be FRAND, or are you going any further than that with these submissions? Because they put it, well, that's one way they put their case, but it's obviously not the only way they put it.
I'm very serious. I'm not arguing that it's not the case that I'm accepting it's arguable that somebody voluntarily could choose. I'm focusing solely on the proposition that we are obliged only to be FRAND, which of course is a necessary condition for an advancee to be obliged. Because unless the licensors are obliged, you can't transfer any obligation feeding through towards advancee. Now, that then leaves the point. So assume I'm right on all that, and assume the assumption I've made is right. Assume that we're not obliged to do this, but somebody might be allowed to do this. Assume that. Does that create a useful purpose, nevertheless, for the declarations sought? And we submit no, because, of course, that's dealing with a hypothesis that Interdigital does not engage in. We do not put forward the license on our behalf as discharging our FRAND. And further, it wouldn't be useful even by analogy, because the two situations are different. The question as to, which you might hypothetically try on a different claim maybe, as to whether Interdigital could hypothetically, totally hypothetically, discharge its ETSI undertaking by a platform license would be a question that related the license and its portfolio. The issues as to whether somebody else, Huawei, Ericsson, ZTE, could discharge their ETSI undertaking by reference platform would depend on their portfolios. So the idea of a useful purpose in the absence of an obligation on Interdigital, just because somebody else might voluntarily do this, that does not give you a useful purpose for this claim against Interdigital.
You don't take a position that you won't rely upon the platform as discharging your FRAND obligation. Your position is that you're not at the moment.
And that we have no,
your position.
and that we have absolutely no intention to.
I'm sorry.
No intention to. We don't give an undertaking, and there's good reasons for that. Who knows what the future holds in some hypothesis in the future. For example, if there was some determination that we had to, but we have absolutely no intention to. And that's where we stand. And there's never been a suggestion that we do or would. And furthermore, to add again to why this is not useful, not sensible, that is not what this claim is about. It is not about getting determinations as to hypotheses as to what Interdigital might do. It's about attacking the platform. So, my Lord, we say that we win on ground one on a slightly different basis to Mr. Nicholson, but we win and actually we would succeed for Mr. Nicholson as well, though on a different logic. Now, well, then briefly, no bilateral claim. It's blatantly obvious when you read the pleading that no claim for a bilateral license is advanced. Tesla has never asked for one. I've taken you to the rate bit, 31 to 32, where what is frowned and what is not frowned is pleaded. It's solely about the Avanti platform. Mr. Alexander, I think, suggested, well, why do we float this idea of a bilateral? Well, it's because if we lose, well, then, if we lose on platforms, then we might want to have a bilateral claim against Interdigital. But that is not what they have pleaded. It is not, it would be a totally different trial to the one that's pleaded. The one that's pleaded is about the platform, all the portfolios. A trial against Interdigital for a bilateral breach is something totally different, depending on conduct in Interdigital and Tesla, and is not engaged by this pleading. If they actually seriously wished a bilateral, they would have asked for one and they would have pleaded it. And also, this is not an accident of pleading. The reason they haven't claimed for a bilateral is clear. It would have torpedoed their representative claim immediately. It would have torpedoed also all their arguments that only a pool license is satisfactory. That's why they've never asked us.
But it may be much simpler than having to resort to torpedoes. They just don't want one.
They just don't want one. It's as simple as that. And also, what you can't allow is some ambiguous floating of a bilateral. In reality, is a stalking horse to get this whole platform coming back in. If it's wrong, it's wrong. And that's where they lose. Well, that then takes me to forum convenience. We say there is no basis to interfere with Miss Justice Fancourt's decision that Tesla hasn't shown that UK is clearly the most appropriate. And in turn also, our forum stay succeeds. Because although his ultimate conclusion was based on service out, his underlying findings positively show the US is the more appropriate forum, and there's no basis to interfere with that. And the second reason why our forum stay succeeds is what we can call the limbo principle, which I outlined at paragraphs 179 to 180 of our case, which is that you look for the claim which is the centre of gravity. And if you have, as so often you do, a mixed service in and service out case, but the real claim is against the foreign defendant served out, and there is no convenient forum against them, and therefore service out has failed, you determine that first, and then the fact that the foreign defendant won't be served out effectively then determines, by way of centre of gravity, tips the balance on any forum convenience stay brought by the defendant served here. And that's just a matter of realities, and is what was found by the Court of Appeal in limbo. It's one of the many rather important points of principle raised by this case, which I'm afraid I have limited time to address. But, so that's how...
You said it's 179 to 180 of your case?
It is, yes.
Thank you.
That's page 110. Now then, there are three issues. The first is characterisation. This is very simple. The principle in re Harrods tells you that you look at substance, not the formal relief chosen in the UK, and that you do so, importantly, from a non-parochial international perspective. The authorities are at paragraph 157 of our case. Applying that, the answer is obvious. As Ms. Justice Fancourt saw, as the Court of Appeal majority saw, this case is about global licensing, about what are the frown terms for a worldwide license. That's how any reasonable business person would see it. Identifying a UK way of framing a claim which is not the reality does not solve characterization. Even if the Vestel logic were otherwise coherent, and it is not, the reality of the claim is worldwide. And test it this way. If Lord Justice Arnold was right, the same claim would be most closely connected to every jurisdiction in the world, equally. You know, the US court applying English law would hold that the US court was most closely connected. The German court applying same principles would say we're the most closely connected. It's inherently illogical when you have a single worldwide claim to say it is most closely connected to the UK. That takes me then to availability. This follows straight from Mr. Justice Fancourt's findings. Again, I do apologise for the rush, but I'm going to have to take this shortly. Paragraph 136 of his judgment says you can have, under US law, a claim for damages for breach and for breach of the ETSI undertakings on a global basis, and that is accepted between the experts. Leaving aside the rate setting question, he finds that is something available in the United States. And that last sentence there of 136 is made good by paragraph 95 of Tesla's skeleton for Mr. Justice Fancourt, which my learned friends have provided, which concedes the point. And for your note also, the evidence makes it good. Contreras 1, 58 to 64, page 634, addressed by Kessler at 37 to 39, page 678, who says you can have a global breach claim, and then Contreras 2 does not disagree, 642. My learned friends sought to distort Mr. Camprath's evidence. And if we can just turn that up very quickly, we go to page 607. It was suggested that he somehow was saying that there could be no breach claim. That is not correct. Firstly, if you go to paragraph 11, he says that I can see that the relief Tesla seeks from the UK court includes a global FRAND determination. Then he says, turn on to the next page, paragraph 14, if a platform pool operator would have a contractual obligation, then the implementer could ask a US court to adjudicate whether such platform pool operator had breached its contract. Then he says this means the following elements of Declarations 5.9 can be brought to a US court, including Declaration 9. My learned friend took you to footnote 2, which says that you need to change the words challenge patents in 9 to read US patents. But when you read that, what does that say? It says, Mr. Camprath is saying that a declaration in the USA, the terms proposed by Avanci for a license covering the Avanci 5G pool, including the US patents, are not FRAND. So Mr. Camprath is absolutely saying you can get a global breach determination in the USA. He's just saying that if you used including wording in the US, you would refer to the US patents. And then further at 16, he also makes clear that all the other declarations, 6, 7, 8, and 10, all concern the relief which Tesla is seeking. So he does not say the global breach claim is unavailable. Further, you've got, I hope, the references to the agreed point that even as to rate setting, it's not that the US courts can't do it, it is possible they can do it. All that Mr. Contreras ever said was that it was unlikely. Now, on that, there's a difference between Lord Justice Arnold and Mr. Justice Fancourt. Justice Fancourt says, well, I think actually it's pretty likely. He says, uses the word surprising if they wouldn't. Lord Justice Arnold disagrees. He has a different reading of the US case law which he engaged in off his own bat, independent of the expert evidence, and he relies on non-Delaware cases. But we submit he shouldn't have done that. But it doesn't matter. Because standing back, what have you got? The US courts can determine FRAND by way of breach, saying this is not FRAND. There is a risk that they may not grant global rate setting as a remedy. There's a risk of that here too. The Court of Appeal said it was impossible. Even if your lordships thought it was arguable, it's not guaranteed to happen. So what do you have? You have simply a proposition that There may be a risk it might not happen in the US, with the US courts doing things the way they do, but interpreting the same French law obligation when there may be a risk here. Possibly there's more risk in the US if Mr. Justice Fancourt is wrong, but does that make the US unavailable applying principle?
Yes, Mr. Raphael, just so that you're aware, you've got 4 more minutes.
Right.
Yeah.
And the answer is no, because all it shows is the US courts might do things differently, and so applying the principle in re Harrods, that is not something that makes the US unavailable. It is simply something that will be tested against the question of whether there's a breach of substantial justice, and Mr. Justice Fancourt held that there would be substantial justice in the USA. Well, that then, so on availability, there is no doubt that his findings make good availability, because he's shown the US courts have personal jurisdiction, and then there's simply no basis to say that a differential risk as to one remedy, even were that established, makes the US courts unavailable. And that would be a parochial conclusion, my lords. It would be you saying, no more, no less, that we do things better as to Fran. Well, that then takes you to connecting factors. And on connecting factors, Miss Justice Fancourt found, in an entirely orthodox fashion, all the connecting factors dominantly connected this claim to the USA. You've seen what he said there. Now, Tesla mentioned, well, what about Tesla UK? But Tesla UK is just added as a jurisdictional hook. The license is between Tesla US and Avanti. It would cover everyone worldwide. They could have joined with just as much force every subsidiary in the world. It makes no difference, and he saw that clearly. The connections he identified, the parties are all there, the rights are there, the dominant number of patents are there, that's where it's been regulated by the US authorities, are all very strong connections. On what basis could you interfere with that finding? Tesla have only identified essentially the reasoning of Lord Justice Arnold, which is, oh, you've got that wrong because there's no such thing as FRAND no such thing as forum in FRAND cases. And as a consequence of that conclusion, Lord Justice Arnold said, well, you could ignore things like location of parties. By the way, that's not domicile, it's real location. You could ignore things like where the rights are, because, in fact, in terms of the practicalities of litigation, you can try this just as well worldwide, because this is really about expert evidence as to rates. But that's a fundamental misconception as to the nature of forum. Because forum is not just about adjudicatory convenience. And we set out the authority in our written case on this. Spiliago is absolutely clear. Conveniens, the Latin, is a trick. This is not just about convenience, it is about appropriateness. And appropriateness is not just about adjudicatory convenience, it's about adjudicatory sovereignty. Which country is most closely connected? Which is more appropriate? And there, the location of the parties is of fundamental importance because it engages allegiance. A bunch of American companies, which is what this is about, would naturally assume their rights and obligations are going to be determined by the US courts. That's to whom they owe allegiance. And indeed, if you just simply say everybody's there, you don't need to go into where the evidence is. It's to be presumed that everybody's there, that means that's where the evidence is, that's where the decision makers are. No more is required.
That may be an appropriate point that's for your conclusion.
If I can have 20 seconds, my lord.
Yes, of course.
So then we submit that there was a fundamental misapprehension of the FRAND jurisdiction, that it completely distorts forum, that combined with 6314 it creates the extraordinary result that basically forum is dead in FRAND cases.
Yes, thank you.
And there we go, my lord.
Thank you very much. Mr. Alexander.
My lords, can I just deal with a few topics? First of all, a point, an overriding point that was made, that this was a free market in which this court should not interfere. this really is very far from a free market, as you will have picked up. First, there are patent rights. Secondly, we're dealing with a market for essential patent rights. It's difficult to think of any other market where essentially customers are obliged to buy a very large number of very small inputs, in this case, license rights for individual patents, of which there may be many thousands, for a subpart of one product, where if they don't take a license on the terms that are sought, they face a risk of their entire major product being excluded entirely from major markets around the world. And it's against that background that this case is brought. And the reason that it's important background for the legal issue is because the approach that Lord Justice Arnold was taking was to say, well, it may be that there is a theoretical availability of bilateral licenses, but just as in Unwired Planet, where there was a theoretical availability of individual country licenses, when you look at the actual market, in order for people to discharge their obligations to make licenses available on fair, reasonable and discriminatory terms, they simply don't do that by just pointing to the theoretical availability of these licenses in a market where you've got to secure licenses from all of those undertakings. That point wasn't really properly analysed by the submissions that were referred to by the Centre for Law and Economics, who take a very theoretical and abstract approach. But it's one that, if one analyses it, actually supports our case, because their proposition was, well, you don't have to worry if there is, in fact, adequate discipline by the availability of outside options. Well, the point here is whether there really is adequate discipline, as a matter of fact, by the availability of outside options, or whether, in fact, that's not the case. And in our respectful submission, that there really isn't. The whole purpose of the ETSI scheme is to ensure that SEP owners are paid on FRAND terms, but that they don't receive above FRAND payments. That's the whole point of the ETSI scheme, and that it's one in which the implementation of what might be called price regulation in respect of standard essential products is an essential component of the scheme. And the idea that one can, as it were, contract out of FRAND in various ways is contrary to the scheme. As to the actual market, I drew attention in opening to some of the actual evidence to which Lord Justice Arnold referred, and which he was in a very good place to consider, bearing in mind that he has looked at a very large number of these cases, and including looking at the various tactics, if I may use that term, that are employed by SEP owners to try and get around their FRAND obligations and ensure that they're actually not effective, that people don't get FRAND licenses, which has included recently trying to get injunctions against undertakings in very major markets while a FRAND determination was actually going on in this country. So Lord Justice Arnold was, in this case, in some senses, better placed from his experience to take a look at the material realistically and say, well, is there is this really a position which maybe, once all of the evidence is examined...
And which paragraphs are you particularly referring to?
In that I particularly refer to paragraph 95, which was the core of his decision. But he referred in paragraph 27 to his review of the evidence. And he referred also to the paragraphs of the pleadings in paragraph 21 to 28 of the statement of claim, which pleads the background context in relation to Tesla's position with respect to it being corralled, if I may put it like that, to take the 4G license, so the earlier generation of the license. As to those contextual matters, you have the submissions on the evidence of Ms. Hopewell. That's at pages 535 to 550 of the bundle, and I respectfully commend those to you, because what they set up is the context, and I only took you to snippets of that. But what they do is provide colour to the proposition underlying the approach that Lord Justice Arnold took. The FSA submissions at 207 to 216 of the bundle. Obviously, we've referred to the UK IPO's points, and in the App Association submissions at 194 to 198, and the CCIA's submissions at 162 to 167. And once one has considered those, the idea that this is a situation where there's discipline by the free market is very hard to sustain. The reality is that major manufacturers are being disciplined into the pools, effectively. We also respectfully invite your attention in this context to the Department of Justice letter that's been mentioned in the submissions, especially at pages 439 to 440, which suggests that they were proceeding on the basis that there was no obligation on licensors to license outside the platform, although some licensors did engage in independent licensing. And as to the attempts of Avanci to discourage the use of outside options, you have the terms of the agreements and the incentives that they provide to those who litigate, but then result in a pool license, not a bilateral license, where you don't get the relevant advantages. And we respectfully submit that both Lord Justice Arnold and, in this respect, Mr. Justice Fancourt, who was in agreement with Lord Justice Arnold in relation to the fundamental point as to whether or not this case had substantive merit, where he differed was on the procedural aspects. But as I'll just remind my lords, this was a situation where, on the substantive issue of the concern that this platform should be subject to scrutiny, there was agreement between at least those judges.
And which paragraph?
The paragraph where that is summarised is in paragraph 159 of Lord Justice Arnold's judgment, where he summarises the point in agreement with Mr. Justice Fancourt. Mr. Justice Fancourt's point is at paragraph 97 of his judgment at page 328
Thank you.
of the bundle. Second point, why Interdigital? My learned friend Mr. Raphael expresses surprise at Interdigital being involved. We respectfully submit that is misplaced. Interdigital and IDPH are the most natural defendants in this context, and the claim against them in respect of individual UK patents is the most natural claim for a very wide range of reasons. First, obviously, they own a significant portfolio of SEPs, including UK SEPs. They're one of the top 10 SEP owners in the world. Secondly, Interdigital is a very substantial company. I think its market capitalization is certainly in the billions. It's not a company that's unable to defend itself. It's been a very long-standing member of ETSI. It has repeatedly and aggressively asserted its SEPs in United Kingdom proceedings, and it has been doing so for some 20 years. There's a record of a report of Mr. Justice Pumphrey in 2004 relating to the GSM standard, where Mr. Justice Pumphrey said, and we can give you the reference to that Interdigital has pursued an aggressive licensing policy, threatening litigation if licenses are not taken, making it clear that its portfolio of patents is so geographically and technically extensive that it is uneconomic to resist. That approach has been taken to this day. That they sued Lenovo in proceedings in which they were alleging that the United Kingdom was the only appropriate forum in which brand terms should be determined. That case, or the Court of Appeal decision from it, is in the bundles, and they were found by the judge there to have consistently sought supra-FRAND rates, and they were found to have been an unwilling licensor.
Reference to that?
The reference to that is in page 1920 of the bundle, and 1925, which is Mr. Justice Mellor's decision. In those proceedings, they were asserting that there should be an injunction preventing Lenovo from selling its cellular products unless Lenovo took the license that Interdigital was seeking, specifically the license settled by this court, and this court alone. And they were complaining against Lenovo, one of the largest manufacturers in the world of cellular compliant equipment, that unless Lenovo agreed to take a license determined by this court, they were themselves unwilling licensees and ought to be subject to an injunction preventing the sale of all Lenovo cellular-enabled equipment in the United Kingdom. And so we would respectfully submit that IDC has a very close connection in a litigation sense with litigation relating to standards essential patents, in which they have asserted that the United Kingdom is the appropriate forum for these matters to be determined over an extended period. There was further litigation that they embarked on against Oppo, and indeed of the Fran trials that have taken place, 2 out of the 4 of them have been at Interdigital's, 2 out of the 5 of them have been at Interdigital's instigation, where they have said, you must take a license settled by the English court. So the idea that they are, as it were, some entirely innocent bystander is just not justifiable. And you see that reflected in the case law in the UK. The next point is that their role is, as a member of the Avanci pool, they were one of the original members of the Avanci pool, that's at 565, and they obviously have a long experience in the industry. And although it's true that they did not commence proceedings against Tesla, they are beneficiaries of it to the extent that Tesla becomes a member of the pool. And there was, as I've referred to, a large litigation campaign brought by other Avanci 4G pool members against Tesla until it entered into the 4G license. And that was a campaign that was conducted across 5 courts in 3 jurisdictions, and it was asserted by a number of the Avanci pool members there that the offers of the Avanci 4G pool licenses were FRAND. And you find that in the evidence on at 536 to 539 of the bundle. Secondly, of course, in connection with Avanci, Avanci is IDC's licensing agent, which itself has repeatedly represented that the 4G terms and the 5G terms are FRAND, even though it now says, well, they don't have to be FRAND, but the representation has been that they are FRAND. So the idea that this is some entirely independent third party is simply wrong.
In relation to 5G, FRAND, as opposed to reasonable commercial rate, is where?
Is in the Department of Justice letter and at 541 to 542.
And you say that amounts to effectively a proclamation to the world that if you take a license through the pool, it will be FRAND and meet our obligation.
That's right.
That's your submission.
That's my submission. You have my submission that on any view, whatever the position in relation to the obligations, there is utility there. Because if it's right that a license through the pool on terms to be determined discharges the obligations of the relevant licensors, that means that everyone can license through the pool in the efficient way on terms that are determined in a properly price-regulated way to be FRAND. And that's a solution that should commend itself actually to everyone, because you then get efficient licensing on FRAND terms through the most efficient way of doing that.
Can I just check? I put it to Mr. Raphael that I understood your case to be that if it was FRAND, if the pool license was FRAND Quoad Interdigital, then it was FRAND Quoad all the SEP owners.
Yes.
And it's an all-or-nothing case. I mean, you may be right, may be wrong, but that's your case.
Yes, that's our case.
Yeah.
And that's not just from nowhere. The reason that we say that is because, as I drew attention in opening, the 4G license was not sought to be justified by reference to an individual analysis of the relevant rights of the members to the pool and some analysis of comparable agreements and so forth. It was essentially described in a half-page email, which I gave the reference to, and I'll give it again in a moment, which simply set out this is the way in which we've done the evaluation. And I'll come back to that in relation to the rights of third parties point. But we say it's just vastly overcomplicating matters to say you need everyone else in, because if the pool license is determined to be FRAND, or an adjustment to the pool license is determined to be FRAND, the problem is completely solved. Indeed, all of the problems are solved in this context. So the final point in relation to IDC's position is they say a letter came out of the blue. Well, I mean, it's very difficult to sustain that or that they were sued out of the blue. They had written us a letter in 2020, that's at page 573, relating to the 4G patents. They had identified a significant number of what were described as exemplary European patents, which have obviously UK counterparts, and they had invited opening discussions relating to a license. Now, in the context of the market of this kind, we would respectfully submit that when someone gets a letter like that from one of the most aggressive patent SEP assertion undertakings really in the world, that's not just simply a would you like to have lunch letter. That is implicitly saying, well, if you don't take a license, there will be consequences. There were United States patents identified and UK patents identified. And so we respectfully say that IDPH, as the patentee of patents that were asserted to require a license in the UK, among other countries, is an entirely appropriate defendant for a declaration in relation to what terms are appropriate to license the patents on. So that's the position in relation to IDC. Avanci, we know, would come in anyway.
Sorry, I'm just looking at page 574. They say you get in touch with us to agree a license, and they draw attention to the fact that they license through the Avanci system as well, and say, well, this might be an attractive option.
Yes, that's exactly my point.
Yeah.
It's not just saying, well, and at that point, of course, my clients were potentially faced with proceedings of others. Ultimately, they joined the Avanci 4G pool. But in our respectful submission, this was actually saying, you know, Avanci is at least in that context a way forward. The next point is on whether the SEP owner can't discharge its ETSI obligations through a pool license. And we think that this point really is no longer live. It was said to be based on the travaux, and really I think that point has gone away. Just for my lords...
I'm not sure it was conceded. Insofar as the argument was sought to be supported by the travaux, that point has gone away. I don't think the argument's gone away.
No, in all respectful submission, we submit that it's plainly the case that a SEP owner can discharge its ETSI obligations by a pool license, and it would be very odd if one couldn't do that, simply on the basis that this is, in some sense, an extremely convenient way of collectively those who've contributed to the standard all getting together and saying, well, let's not bother doing these individual negotiations. If we've got a license that everyone agrees is friend, let's enter into that license. My lords will recall that in the Mitsubishi case, to which we refer in our written case, Mr. Justice Meller held that it was at the very least very distinctly arguable that the court at the Fran trial may find that the MC pool license administered, it was not this pool, but it was a different pool, administered and offered by the second claimant was Fran, and that for an implementer to refuse a pool license but to insist only on a bilateral license would require justification in a case where the pool comprised patents claimed to be essential to the standard. And that you find in Mitsubishi, and the page reference is page 2386 of the bundle. In relation to the travaux, all you need on that is a few pages, and I'll just give you the references and what they say. The draft clause which was said to be relevant is at page 704, clause 15.1. We submit it obviously has nothing to do with this issue. The letters that were said to have given, to which followed that, which were said to relate to this, Again, none of the letters mention this clause, or indeed any clauses. Those are 739 to 755. And when one follows the subsequent discussion in the groups dealing with this issue, it becomes clear that there were 4 issues that were taxing the parties. We don't really need to go into this now. You see that at 787.
Yes, sorry. I thought we reached the position that the Travo are no longer relied upon in support of this.
The material on your wider submission that
Yes.
a pool license must be FRAND.
Yes.
Because, well, for my part, it seemed to me the Travo were quite helpful in enabling one to assess how strong that case was.
Yes.
But they don't butter any parsnips in relation to your more general submission that you can use a pool license to discharge your ETSI obligation.
That's the point.
Yeah.
That's the point. But if in insofar as it was said that this was specifically debated, no, it wasn't. There were 4 points that were debated, including arbitration and various other points about how it...
But as I understand, you don't rely on the Travo in support of your wider claim in paragraph 27.1
No.
of your case? No.
No. So if I can then come back to the real issue, what we say is the real issue, which is whether Lord Justice Arnold's analysis in paragraphs 95 to 102 were right. And we respectfully submit that they clearly are. Paragraph 95, which was at the heart of it.
Can you just help me back to the page now?
I'm sorry. It's page 261.
Thank you. Yep.
Was an evaluation that he undertook against, as I said, the background that he recorded in paragraph 27 at page 242, and the commercial licensing practices which he must have been aware of, at least by reference to the pleaded case, since he referred to them specifically in his judgment at paragraph 34. But there was extensive evidence, as I've referred my lords to, about the nature of the market and how these and how this actually worked. And Lord Justice Arnold held, in common with Mr. Justice Francourt, that the declaration sought against Interdigital engaged legally enforceable rights against Interdigital. And I've given my lords the reference to Mr. Justice Francourt's judgment there.
Do you rely on the... Lord Justice Arnold relied on points made by counsel for Avanci. Do you rely upon the points made by counsel for Avanci before this court?
In my submission, they don't take matters really any further.
Than this, yeah.
The core is in 95, and if anything, it does slightly support our submissions in that. If one says, well, here is the alternative to licensing through the pool, and that is...
I mean, I thought Mr. Nicholson was making the point very powerfully about the convenience of
Yes.
the Avanci platform.
Yes.
I was half expecting you to say in reply to my lord, yes, you do rely on that, because that shows the contrast between
yes.
having to go around the houses seeking bilateral license.
Yes, I certainly rely on the convenience of it. What I don't rely on is the fact that it was a point made by my learned friend, but the convenience of the point, absolutely. That's the reason, in some sense, why we're here. It's because it's a good way of licensing, not because it's a bad way of licensing. It's because the alternative is so unattractive that this is the substance. And in relation to the utility, we respectfully submit that the paragraphs 96 to 98 are all well justifiable in terms of useful purpose, and are reinforced by the fact that the evidence is that licensors would essentially fall in if there was a determination by this court as to the FRANness or otherwise of the license. This is not creating a contractual obligation out of commercial practice. We are using the commercial context to inform how the substance of the ETSI obligation needs to be fulfilled.
Yeah, and I think you're entitled to say that was the patent in on Wild Planet.
Exactly, and that's what happened.
It's a broad standard as a legal obligation. How do you fill in the detail of that? You look at commercial practice.
Exactly, and it's that point that, with great respect, the majority of the Court of Appeal didn't really grapple with. It's not an answer to say there isn't an obligation to license collectively to that particular point. So, in all respectful submission, it would be it would be regrettable if this court were to say that it's unarguable that the Avanci terms must be FRAND or determine what is required in order to make them so. It would be a retrograde step. Finally, Tyne and Weir, the analysis there. We submit this is a case very much along the lines, indeed, our fortiori paragraph 48 of Tyne and Weir, or Nexus case, where the right defendant with the relevant right is sued. The defendant who is able to defend the case fully, Avanci, is able to come in and will inevitably come in. That can be, if there's anyone else who wants to participate, that can be case managed in due course. It is actually not likely that others will necessarily want to participate, partly because they haven't really been interested in even how the terms of the Avanci license have been set so far. And secondly, if the license is defended in the same way that the 4G license was defended by Avanci, they may have very little to offer. So this is not one of these situations where you can say, well, each of the individual defendants is likely to have something additional to contribute to the
and they
resolution.
May also just not want to be bound.
They may not want to be. They may not want to participate. And as to costs, if my learned friends, clients don't want to take an active role in defending the pool terms, they don't have to. Doubtless, if they don't have to, and they don't, and they take a strictly neutral position, that will be sorted out in costs in due course.
Well,
they don't have
they
to.
are under a cost risk.
They may be.
Mr. Raphael made the point. It's all very well saying, well, we could just sit on the sidelines and watch Avanci doing the defence. That doesn't deal with the cost risk if they're on the losing side at the end of the day. How's that to be solved?
Well, what one could do is potentially make preemptive costs orders if they said, well, if we're not going to participate, then the terms upon which this case should go forward are that they're not liable for costs if they take a neutral position.
Well, as I understand, nobody has suggested that yet.
No.
They're simply in if they're in, and they're on cost risk if they lose.
No, that's right, but this is not something that would be unmanageable in our submission. I would need to take instructions in relation to that, obviously, if that was the way forward. But that shouldn't be a bar to there being a serious issue, if otherwise there was.
No, it was really raised in the context that the costs and risks of Interdigital getting involved in a dispute about the pool licence were disproportionate to the benefit. And the cost risk was the one that really struck home in the sense that it wouldn't be solved just by Interdigital sitting on the sidelines.
Yes, that may be right, and it may be that one needs to think about how to manage that. If it was said, well, the case can only proceed on the basis that we don't seek costs against Interdigital.
Well, that's an obvious solution, but not one I'm aware that's been put forward.
My lord is right, but if that were, as it were, a condition upon which the action should proceed, it's doubtless upon something, a matter on which I could take instructions. That shouldn't be the bar. This is at that point, or the way of solving it has only just arisen.
Yes.
As regards jurisdiction, as I mentioned in opening, we say there are two matters in play. There's the territorial patent rights and the ETSI regime that is intended to act as a constraint on those territorial patent rights, and it requires the patentee to grant FRAND licenses and for implementers to be free from the threat of injunction if they take them. When the court determines the FRAND terms of a license, it's not determining appropriate relief for foreign rights, that's on White Planet. is determining what the SEP owner must do to meet its obligation to ETSI and what the implementer must accept to avoid territorial infringement. And we say that underpins the analysis in Vestel from Lord Justice Burse on Gateway 11, and why we say it's right to say the subject matter of the claim, wholly or principally, is within the jurisdiction. The subject matter of the claim are declarations of the terms respondents must offer to avoid infringement of the UK SEPs, one of our fourth largest market. And the only property rights engaged by that claim are the UK SEPs, and we say that flows from Unwired Planet. My learned friends have said, well, a different analysis may be appropriate when one gets to forum conveniens and looking at a dispute as a whole. And my learned friend, Ms. Pickard, referred to Lord Lloyd-Jones in Brownlee 2, where he said there's no need to adopt an unnaturally restrictive meaning to gateways because the discretionary forum analysis acts as a safety valve, and that's in Authorities 2, page 1723. Today, my learned friend Mr. Raphael said that we are not a Vestel case because he pointed to paragraph 71 in Vestel where Lord Justice Burse said that the claim had been narrowed there, and my learned friend said we had not narrowed our claim. That's not right. In that claim, it was narrowed. It was narrowed to a licence to the UK SEPs on global terms, and so it does end up in the same place that we are here. And for my Lord's note, that is page 3049, paragraph 21, and 3055, paragraph 66. As regards 6314, you have my submissions on that relating to a patent cannot sensibly be read to exclude a claim as to the terms that must be offered to be able to work that patent and not infringe that patent. And we say that Lord Justice Arnold was completely right in his analysis with respect in his paragraph 210. And we also commend the trio of cases where the High Court have said that is correct, and that is in our case at paragraphs 73 to 75. Activists and Lilly was a very different case because there it was 6314 was being used to try to serve a claim form for determination of infringement of foreign patent rights. That's not this case. And today, Mr. Raphael said that Lord Justice Arnold's approach in paragraph 210 of his judgment was wrong for 4 different reasons. First, he says that this is not a claim relating to infringement of UK patent rights. We say that is wrong. It is a claim for Tesla to determine or ask the court to determine what it needs to pay to avoid the consequences of infringement. The second point was the challenged patents are entirely artificial. That's not right. What he misses there is that the challenged patents are declared by Interdigital to be SEPs. And therefore, Interdigital say a license must be taken to them in order to work the standard. And we only have to infringe one SEP, and we cannot work the 5G standard. And that is a function of standardization of the technology, and it goes back to why the ETSI undertaking is there in the first place. His third point was it's wrong to suggest there's any threat from Interdigital. That's his innocent bystander point, and my learned friend Mr. Alexander has addressed you on that. And his final point was, well, not all addresses for services have to be in the UK. Now, that's not this case and doesn't arise before you. It is a thorny issue that was about to be considered by Mr. Justice Mead in the Warner Brothers litigation arising out of the United Kingdom's exit from the EU, because addresses for service were always allowed for EEA, and one didn't need permission for service in the EEA, and now the EEA, you do need permission. So there is a wrinkle there that but does not arise in this, because the addresses for service here are UK. And finally, he did have a sixth point, which was he referred to international concerns about this court's approach. If he is referring to the recent Amazon and Interdigital litigation and how case has been managed both here and in the UPC and Germany. If that is what he's referring to, that's about interim declarations and about the different approaches that the courts have taken both to interim declarations of licenses and terms. It was considered by the Court of Appeal recently in Samsung and ZTE and does not arise before my lords on this appeal. Now, we say when looking at Gateway 11 and 6314 as a whole, one has to be very clear as to the effects. And one of the points my learned friends have continued to make is that there is a very big distinction between a SEP owner claim and an implementer claim. But one has to realise that that actually, in practice, is not what has happened since Unwired Planet. And there is no bright line between the two. What has happened is the courts have taken what's called a FRAND-first approach to managing these claims. So FRAND trials happen before technical trials, and the reason for that is in the practical reality of a large portfolio, such as Interdigital's, the SEP owner is probably going to have at least one valid and essential SEP, and it only needs one. And so the real issue is what needs to be paid. And my lords will find that described by Mr. Justice Mead in Nokia Oppo on page 2531 to 2532 under the heading Reflections, and also by Lord Justice Arnold, who makes clear this is now the approach in most cases. He says that in Panasonic and Xiaomi at pages 2657 to 2659.
I don't think I got your last page reference.
Oh, sorry, that was 2531 to 2532.
Thank you.
That's the judges dealing with this at the coalface, so to speak.
That's right, on the coalface. And the fact that the judges, we say the reason the practice has arisen on the coalface is because it's a reflection that the same issue arises in both types of claim, which is what are the terms needed to avoid the consequences of infringement in the UK. Now turning to available forum, and starting with Interdigital, as we pointed out in paragraph 113 of our written case, IDPH failed to show that Delaware is more appropriate than England, both before Mr. Justice Fancourt and before Lord Justice Arnold. And we say, and indeed my own friends impress upon you, that there's no reason for the court to take a different view. Mr. Justice Fancourt found that in paragraph 143 on page 337. IDPH had specifically requested the court should decline jurisdiction over IDPH in favour of Delaware, but the judge held they had not established that the US court would be a more appropriate forum for any licensing claim against IDPH. He therefore declined that declaration. He struck out the claim for different reasons, for his serious issue to be tried reasons. And on page 329, at paragraphs 102 to 103, he also held that IDH would be a proper party to any claim going forward against IDPH, for the very reason that one's the patent holder and one is the company in the same group that gives the ETSI undertaking on behalf of that holder. And the same was held by Lord Justice Arnold in his paragraph 217. Now today, my own friend said that they were wrong because it offended what he called the limbo principle, where the real claim should be assessed against the defendant where it really matters. But we don't accept that approach in this case, because the claim really, it's not that we disagree with limbo, it's we say that in this case, the claim that really matters is against IDPH, because they are the patentee who can sue us. They are the patentee who can enforce their SEPs in the United Kingdom. And the fact that internally they decided that another interdigital company, IDC, takes the role of the licensing and gives the declaration on their behalf, does not make that company the central defendant. And so we say both courts below were correct, and that there are no grounds that this claim could not continue, jurisdictional grounds, against Interdigital.
Mr. Lichiadopoulos, just to give you 5 minutes warning. Yep.
Thank you, my Lord. So turning then to availability more generally, Ms Pickard said that we had said that there was power to determine the dispute in Delaware in paragraph 95 of our skeleton. We did not. We explained that there's no statutory or common law bar, but global rate setting without consent would be unlikely. The big point, I think, on this is the Continental case. We referred in opening to the decisions of the other district courts in Optis, and they are relevant for the reasons set in our evidence because the subject matter jurisdiction problem arises from federal patent law and therefore is applied by district courts, and that's explained by Professor Contreras on page 626 and 637. In relation to the case on which their case, Continental, 2 points were raised. One, that the fact that it included another licence was irrelevant, and secondly, that Lord Justice Arnold impermissibly imposed his own view. On the first of those, I would just refer you to page 3195, because there the district court made clear that there was going to be going ahead a claim for global licensing arising from a pre-existing agreement, and the subject matter of that was the same as arising from the Fran claims. So a very different case to the present case, indeed one might say, another consent case. And as for Lord Justice Arnold impermissibly imposing his own view, that's a very unfair criticism, we say, in that what he held in his paragraph 147 in relation to Continental entirely accords with the evidence of Professor Contreras on this point at Contreras 2, pages 646 to 648. The bottom line, my lords, we say, is that there is significant doubt, we say further than that, about whether the United States and Delaware would be able to hear a claim like this, and that is due to consent, and the one thing that the respondents will not do is give that consent. And so there you have a situation where this is not like Harrods, where all the questions and factual issues favoured Argentina. There was no dispute in Harrods that consent was needed for Argentina, or it wasn't available. Here, there is no dispute over the UK, subject to the issues that my learned friend has addressed you on, but not jurisdictional issues. And what we have over the United States is a case where both judges below accepted that there was doubt at the very least. Mr. Justice Fancourt took a different view of connecting factors, but this was based on a characterisation which we say overlooked that the purpose of the claim is to know what do we need to pay to launch in the UK market. And Tesla UK is not irrelevant to that, and neither is the UK irrelevant to that, and the UK court is the appropriate forum to determine that issue. My Lord, if I can help you further, those are answers.
You've come in under time. Did anyone have any questions? No. Thank you very much. The Court's very grateful to Council for their submissions, very grateful to everyone that has assisted in the preparation of these cases. There's a lot to think about. We will take some time to consider our judgment. The Court's now adjourned. Thank you.